So, welcome back today for the second session of Business Law lecture. Yesterday, we were talking about the company law and up to this particular site where we discussed about incorporation of a company. And I explained to you finally who is a shareholder. So today we are going to proceed further with this, and let us see what are the areas that we are going to discuss in today's lecture. Now, I would like to focus your attention to the categories and classes of shares of a company. Now, there are several categories or classes rather in shareholding. The shareholders of a company whom you know now, having gone through the lecture yesterday, these shareholders may fall into several categories depending on the type of shares that they subscribe. The first category of shares that shareholders could subscribe are called the ordinary shares. Now, ordinary shares are the basic form of shares that gives one vote per share, which means that a shareholder will hold one vote for each of the shares that he subscribed in the company. And it makes the shareholder entitled to equality of dividends, which means that the dividend at profit at the end of a year will be based on the number of shares that a particular ordinary shareholder holds in the company, with the entitlement towards distribution of remaining assets at a winding up. That is where, when there is a dissolution of the company, the particular shareholder will own as to the number of shares, the proportion of which the assets of the company could be devolved to that particular shareholder. So, ordinary shareholders are a common category of shareholders that anyone investing in the company would prefer to have. And also yesterday, in the case of Solomon versus Solomon and Company Limited, we saw that Solomon was holding these ordinary shares in addition to the debentures that he held in the company. The second category of shares are called preference shares or preferential shares. Now, these shares have a ranking above ordinary shares, which means that these shares have been given on preference basis to certain people who have an interest in the company in specified aspects, with a priority to a fixed dividend, where they obtain a fixed dividend at profit every year based on the number of preferential shares that a particular shareholder is holding. And to a return of capital, what he has invested in the company, he would be entitled to obtain at the time of a winding up of a company or at its dissolution. So therefore, preferential shareholders or preference shares are enabled to obtain these fixed dividends and the capital that they invest in the company either at the end of a financial year or at the winding up or closure. The third category of shares are called the deferred shares. These shares are issued with limited rights, with no rights to dividends during a particular period, but to enable private investors to take capital growth instead of dividend income generally issued to founders of the company or the directors of the company. However, they have no rights to a company's remaining assets in the event of a bankruptcy or at closure, such as a winding up, until all common and preferred shareholders have been paid or settled. So therefore, the deferred shareholders rank below the preferential shareholders and ordinary shareholders. The fourth category of shares are called the non-voting shares. As the term sounds, these shareholders do not have any voting powers at any meetings of the company. It may be general meetings, it may be special meetings, it may be annual general meetings, or it may be special general meetings, at which they hold no voting right as per the shares that they hold. Shares which do not carry voting rights at all, or which carry limited rights of voting in specified situations. So therefore, voting right can be bestowed on a shareholder if the articles have specifically mentioned that such shareholders will hold voting rights in these specified situations as set out in the Articles of Association. These shares are only issued by a public listed company. The companies that are listed in the stock exchange, and for that reason these shareholders play some kind of a different role against the other types of shareholders, such as the ordinary, preference and deferred shareholders. So actually these shareholders obtain their shares from the stock market in reality in the public listed companies, and for those reasons they do not hold any voting right unless the articles allow such voting. Such shares are usually issued for the purpose of retaining control with the promoters of the company. Yesterday I explained to you all who is a promoter and what sort of rights and privileges that the promoters hold in pre-incorporation circumstances. The last or the fifth type of shares are called the redeemable shares. As the word sound again, these shares are redeemable by the shareholders. They are known as buyback shares, where the company may buy back such shares given to shareholders, and these shares can therefore be redeemed for the money that the company pays. So these shares at the option of the company or the shareholders who are holding other types of shares, such as the ordinary shareholders, or on a fixed date or upon an occurrence of an event specified either on the basis of predetermined price or a formula set against the share values, these shares can be redeemable by the company against the payment that it makes to such shareholders. Now, let me take you through the rights and liabilities of shareholders. This area is very important because we wonder what are the rights, entitlements, privileges that the shareholders hold in a company, and what sort of a liability that they may incur for the reason of holding shares in such company. Actually, when it comes to rights and powers of a shareholder, shareholders, as I mentioned to you previously, are considered the real owners of the company, though the company has a distinct personality, separate and distinct and apart from the company itself. First of all, the shareholder status cannot be altered unless special resolution, which means that the type of shareholding that the shareholders are engaged in the company cannot be altered unless by special resolution. What is a special resolution? A special resolution is a matter that is to be taken up in any of the company meetings where the company attend to such matter as a special resolution pertaining to a particular subject or to a shareholder. The shareholders also has the right to vote at all company meetings of the shareholders, except the category of non-voting shareholders, as I explained to you before, that in most cases they do not hold the right to hold the voting right. So these shareholders, not only they can vote at shareholders meetings, but also at the annual general meeting, extraordinary general meetings, and so forth. They can also alter the company's articles, in the sense that as far as the amendments are concerned to the Articles of Association, these shareholders are entitled to propose and pass any alteration that may be affected to the Articles of Association. Shareholders play a major role in taking important decisions for the company, as they are the primary actors in a company that as I explained to you yesterday. So they can approve as well as disapprove any major transaction that take place in a company. For example, if a particular company would want to engage in big transactions or even move into other areas of businesses that are not particularly mentioned in the Articles of Association, they can first approve such major transaction and thereafter proceed to the altering of the company's articles, which I explained before. And also, they have an authority to amalgamate the company with other companies that this particular company buy out. So in a kind of a merger, acquisition, or any amalgamation of a company with some other elements in the business sphere, they could do so by approving such amalgamation of the company. They also has the power to reduce the company's stated capital, thereby allowing the company to move forward in attracting more capital into the company from outside sources. They also have the power to resolve the voluntary winding up of the company, which means that the shareholders can get together and close down the company affairs so that the company would cease to exist upon such a allowed winding up in the process or in the area of voluntary winding up of the shareholders. So we see that the shareholders in particular have a major role to play in deciding whether a company should exist or discontinue. The shareholders also have the power to change the name of the company. Sometimes we see that certain companies that start with a particular name change its name thereafter based on the decision of the shareholders in particular, and effect such name change with the Register of Companies in the same way as it deals with the registration, incorporation of the company, and thereby make a new name for the company for no certain decisions that the shareholders take. The other power or entitlement or right of a shareholder is that the shareholder can change the status of the company. Status in the sense that it can be a private company, but later on may be converted into a public company or a guarantee company as far as the articles so allow, and even the articles can be amended so as to make the shareholders' decision in converting the status of a company or changing of a company be effective. Also, the shareholders can require the company to purchase the minority shares. There are sometimes in companies certain shareholders that hold less than 5% of shares in a particular company. The shareholders that have more than that figure may propose to the minority shareholders to sell their shares to the other shareholders so that the other shareholders can effect a minority buyout. And also take action against oppression and mismanagement of the company, which I would explain later on what it really means by oppression and mismanagement. But basically, when the directors of a company act in the detriment or in prejudice to a company's affairs, the shareholders have the power to convene meetings or even to go to courts and seek legal action in taking decisions with regard to oppression and mismanagement, and thereby even remove the particular directors who are acting in detriment to the company's affairs. And also, the shareholders in such oppression or mismanagement circumstance can seek not only the final remedy from the court, but also interim injunctive remedies such as to prevent such misconduct being happening due to the actions of the directors, to prevent them from acting further until the case is heard by the particular court, thereby obtaining an injunctive relief, or what we call the interim reliefs or even the permanent reliefs of such nature, to prevent any prejudice being occurred to the company and the company affairs that could be of an irreparable extent. Another important area or an action that the shareholders can take is bring a derivative action. A derivative action is also, I will explain later in this lecture series, but it simply means that when some directors or shareholders are again acting against the interest of a company, a particular shareholder, for the benefit and the interest of the company, can, by representing the particular company, take action against those who are acting against the interest of that company, thereby protecting the company as a distinct person, as a separate person, and protect the affairs of the company without being prejudiced due to these actions of certain shareholders or directors. Let us now turn our attention to what are the liabilities of a shareholder. Now, we saw in discussing about the rights of shareholders, the shareholders' rights are so immense. Obviously, due to the fact that they are the real owners behind that particular corporate wall I was talking about yesterday, the particular corporate veil. And they do in fact act for the benefit and the interest of the company, and therefore much of the rights have been afforded to these shareholders for the existence of these companies. One of the liabilities of the shareholder who holds shares in a company is that, or the primary liability depends on the type of the company against the held shares. That is, depending on the fact whether a particular company is limited by shares or unlimited by shares or guaranteed by shares. So the primary liability of a shareholder would be to make sure that the limited company act in such a manner, thereby letting it hold limited liability, or if it's an unlimited liability company, the shareholders become unlimited in the liability that they hold, and therefore to be mindful of the matters that they are involved with. And in a guarantee company, limited by guarantee, the shareholders also do have a primary liability, that they invest the money at any time that the company calls for the shares to be paid as per the guarantees that the shareholders have given. So therefore, in a case of a limited liability company, the shareholder needs to provide the liability that it has given to be liable at a limit, and to pay the shareholding or the share value at a time the company has called for the shares, or in an unlimited liability company to hold unlimited liability for the company when the company is in some kind of a situation that it needs to meet the liabilities of to those who have those liabilities to the, or rather they have the rights to those companies, so that the shareholders have to bear unlimited liability. In the case of a guarantee company, as I mentioned, that the particular shareholders have to guarantee that, or rather they will have to meet up the shareholding that they have guaranteed in such company. And also the shareholder is liable for any pure private act in terms of contract, to mean that a contract entered between the company and a third party, the shareholders take the primary liability if the company cannot, or rather the company, the particular shareholder or the director has taken a certain illegal type of an activity in a contract, the shareholder becomes liable. Especially when a shareholder has entered into a company by way of an act of ultra vires or outside its scope, and then to such contracts and the contractual obligations and the effects of such contract, the shareholder becomes liable to the contract that the company has entered into with such third party. Also, the company is liable, or rather the shareholder is liable, for any tortious actions that the particular shareholder is responsible in case, again, acting in out of scope or acting in ultra vires, any civil wrong, damage, loss caused to a third party that deals with a company, then the particular shareholder may become liable in case the company, the shareholder has acted in such a manner to create a wrong, civil wrong, or some prejudicial act to that third party that deals with the company affairs. And also the shareholder has a fiduciary duty towards the company. Fiduciary in the sense, the trustworthiness. The shareholder has to act in a trustworthy manner, so that the shareholder would not act in a manner that breaches the trust of a third party that deals with a company, and by its private act, pure private act, as I have mentioned, where a shareholder has breached its duty of trustworthiness or the fiduciary duty, as we say, towards any such affair. And also a shareholder is liable for any private act that may cause wrong that is actionable in terms of any other types of actions that fall outside contract, tort, or fiduciary duty. An actionable wrong in the sense where a cause of action has arisen to someone or even to a company against a particular shareholder due to the private act of that particular shareholder, and that this particular cause of action gives rise to the imposition of liability against a particular shareholder. Now, most of these matters come within the concept of piercing of the corporate veil, which I will explain later when I touch the particular topic. Also, the shareholders have the liability to pay for the share in respect of a call, depending on the type of shares that I explained before. May it be ordinary, preference, redeemable, whatever, the 5 categories of shares that I discussed. And whenever the company calls for, or at a dissolution of a company, the shareholders are liable to pay up the shares that they have subscribed to in that particular company. In what circumstance a shareholder be exonerated from liability, or where a shareholder will be accepted from the liability he or she holds? There are certain instances where a shareholder may be exonerated from his liability that he has towards the company or to other third parties that deal with the company. One area is where any act, default or obligation of the company that the company become liable towards another third party to which there had been no private act of the shareholder, which means that the shareholder has not acted in ultra vires, or it is not an act of privity or private act of him or her that had resulted in certain wrongdoing or a liability imposed against the company, inflicted to a third party that deals with the company. So, any act, default, obligation of the company that the company is responsible and liable, the shareholder, as long as he has not acted in ultra vires or not acted outside the scope of authority, the shareholder will not be liable. Now, this is a very important area, that shareholders do not hold liability for any act committed by the company, since the company has its own personality, distinct and separate from the shareholders, where that particular company is answerable, responsible and liable by itself. And the shareholders, as long as they have not acted out of their scope, will not be liable for such an act or omission committed by a company. The second type of an exoneration from liability afforded to shareholders is where there is an alteration of the articles of association of the company. Now, you may wonder how an alteration of the association of the company may not pass the liability on the shareholder, since such alterations may come due to the acts or action or decision of the shareholders in particular. This is because once the alteration of articles of association have been effected by the company's shareholding at a special meeting or at an annual general meeting, thereafter these amendments, alterations become part and parcel of the company's constitution, which is the article of association. So, in consequence, the shareholders thereafter will not be liable for any alteration that may have taken place in the company articles. Also, the shareholders will be exonerated from their liability when they are required to acquire more shares from others. That is to mean that the shareholders requiring to hold or acquire more shares as a means of certain shareholders go out of the company, the shareholding of those shareholders fall back to the company's existing shareholders. And for that particular shareholding that comes back to the prevailing shareholders, these remaining shareholders will not be liable with respect to those shares. Take for example that there are few parties involved as shareholders in a company called A, B, C and D. In case D leaves the company and D would want to return its shares to the company, the remaining A, B, C shareholders will not be liable to pay off these shares at any time of dissolution of the company or at bankruptcy, since A, B, C shareholders are only liable for the respective shares that they are holding at such bankruptcy, winding up or closure of the company. They are also the former holders of the shares on call when call is made. Those shares that have fallen back to the company, the remaining shareholders will not become liable to settle against those shares that have been previously owned by other shareholders who have already left the company. And these A, B, C shareholders who are remaining will again be only liable with respect to their shares and not to the shares of D. Now we come to a very interesting case in this respect, known as the Ashbury Railway Carriage and Iron Company versus Riche. What happened in this case was that the Ashbury Railway Carriage and Iron Company had a memorandum of association that stated among its objects to make and sell or lend on hire railway carriages. And further, that activities beyond the stated object needs a special resolution. So it is clear that this particular company's business affairs should be limited as per the memorandum of association, or rather now we can call it the articles of association, the constitution, according to which it says that the powers or the affairs of the company were to make, sell or lend on hire railway carriages, nothing else. And further, the article said that if the particular company wants to go more beyond its activities and venture into new areas, then of course a special resolution needed to be passed at the company meetings, thereby amending the company articles to take on such a new line of business. Now here the company Ashbury Railway Company and Iron Company agreed to give a loan to Riche and his brother to build a railway from Antwerp in Belgium to Tona in Belgium. But later the company repudiated the agreement. Now you see what happened here was that the company decided to give a loan facility to a person called Rishi and his brother to build a railway. In order to take the decision to lend money in such nature, the company's articles or memorandum, the constitution, did not allow the company to grant such a loan. Because in the first paragraph I mentioned that the very purpose for which the company was made and operate to make and sell lend on hire railway carriages. So there is nothing mentioned regarding any loan facility that the company could give to anyone. So this is a kind of a situation where the company act out of its scope. Some affair that is not mentioned in the company's articles or memorandum rather. And if the company had done so, the company itself has acted in ultra vires, outside its scope. So what the company did was, they entered into an agreement to lend the money, but later it repudiated the agreement. They cancelled the agreement. Then Rishi and brother went to courts stating that the company has acted in such a way to cancel an agreement that had been entered. The House of Lords in England held that the company has pursued objects beyond its scope. As I mentioned, provided by its memorandum of association, and such actions are acts of ultra vires or acting outside the scope for which the company was to function. Therefore, the agreement that the company entered with Riche is in fact invalid or not valid, because the company did not have the authority formulated by its own memorandum of association to lend the money to Riche and his brothers, and therefore the agreement is initially void and the agreement has no flow thereafter as far as the company is concerned, and therefore Riche and his brother could not maintain a proper case against the Ashbury company, because the agreement that Ashbury company made and thereafter cancelled had no legal validity from the beginning, and therefore Riche and brother has no cause of action against the company. These acts of ultra vires include acting in excess of power, acting in abuse of power, acting with lack of power. Now what do you mean by act of ultra vires is that when someone is acting in excess of power, which means that acting in excess of what have been granted as powers, then any action pursuant to such an act is indeed an act of ultra vires, or which is void, not valid, and unenforceable in law, as well as any action in abuse of powers, or when a company or someone acts in such a way that it abuses the powers that had been already vested with that person or the company, then acting in abuse of such powers or in breach of such powers, it constitutes act of ultra vires, or what we call beyond the scope of what the powers have been granted. Also, the third situation is where someone or a company is acting in lack of power, or where there is no power at all for that person or the company to act, but however, that person or the company has acted. And therefore, such an act is indeed an act of ultra vires. I would like to take you through another question that has come up in the areas that we have covered in our lecture series till now. In this particular question, Amal and Kamal intended to form a company by the name of the Golden Oldies Private Limited. They also intend to dispose of the object clause from the articles of association of the proposed company. Upon inquiry from the Department of Register of Companies, an official informed them that a company already exists under the name of Golden Oldies Company Limited. Now, recalling what we learned yesterday, let us try to explain as required these two areas. Firstly, it requires you to explain whether Amal and Kamal can register the company under the proposed name. Now, we know that when there is an existing company in the same name, then there is no way that we could form another company in the same name. I also mentioned that it's not only the same name, but also if the particular name that you intend to incorporate a new company has somewhat similar meaning or similar style, then such a company will not be registered by the Register of Companies. So, there needs to be some kind of change to make it distinct or different from that of the existing name. And also, I mentioned there are certain names which cannot be used as well in forming companies. So, you are required to explain this situation in line with the Companies Act. Secondly, it is asking to explain what is meant by the object clause and whether it can be dispensed of the articles of association of the proposed company. Now, I told you that the object clause is very important clause that will specifically mention the purpose for which this company is formed. For what purpose? It is a primary obligation of the creators to mention the purpose for which or the objectives of which this company will be formed. Without the objects, no company can be formed. And we saw in the Ashbury Railway Company also that the bar that it had to enter into an agreement that is not allowed in its constitution or the memorandum of association is that it lacked the power to give a loan facility to Rishi and the brother. So, this is where the cardinal theory comes in, that a company shall always have an object clause. the objective, the purpose of which, for which the company is formed. So without the object clause, you cannot form a company. You cannot incorporate a company under the company's law. So this is how you need to explain in your answer to this question. Let us look at this question. Benjamin is carrying on printing business as a sole proprietorship. He wants to convert his business into a company in the form of either a company limited by guarantee or a private limited company. However, he has the following main requirements. For the moment, he does not want to involve any other parties as owners of the company. In the future, he may wish to have a limited number of members or shareholders in the company. What you are required to do is to explain from the two forms given above the type of company that is best suited for Benjamin's purposes. Now, if you go back to the question, it is very clear that at the moment he is running a sole proprietorship. Something similar to what Solomon was running his shoe business in that case. But now he wants to convert his business into a company. Likewise, Solomon, who also wanted to convert his company. But here, in the form of either a company limited by guarantee or a private limited company. However, he has the following main requirements. For the moment, he does not want to involve any other parties as owners of the company, which means that if he is going to be the sole shareholder of a company, he cannot form a guarantee company. That is for sure. So therefore, the only alternate that he would have is to form a private limited company, limited by shares, where he becomes the sole shareholder. Secondly, he also has in mind in the future to have a limited number of members, shareholders in the company, which is quite aptly possible that he could alter his articles of association as the shareholder and thereby allow the entry of other shareholders to come in or other parties to come in and own shares. So looking at the entire scenario, it is the best solution for Benjamin to form private limited company. So this is how you need to address your answer. I would like to revisit this. Have you found any fishy thing? In our law, it is very specifically mentioned that a private person having or being a single shareholder cannot form a private company, or rather a company. That is because a company cannot be formed unless the particular shareholder is the government treasury that can have a single shareholding company. No one else can form a company with a single shareholding. So, the answer to this question is that Benjamin, being the sole shareholder, cannot form this company that he intends. He needs to have at least another person to form the company. So, this is where we have to be extremely cautious in a question like this. Although we can explain the answer in the way I previously mentioned, finally, the matter that a single shareholder company can be formed would become a bar in incorporating the company. So, therefore, the Benjamin will not be able as a single shareholder to form a company unless Benjamin is the treasury, secretary to the treasury of the government, which is not disclosed here. And also the question asks whether he can form a company limited by guarantee or a private limited company and not a public company. And we know that the secretary to the treasury, if he is forming like that, can form only a public company for the government of Sri Lanka. Now, here we come to that situation where the secretary to the treasury can form a single shareholding company for the government. Here the question is, Chathura Senarath is the secretary to the treasury of Sri Lanka. As a secretary to the treasury, he holds shares on behalf of the government of Sri Lanka in various companies incorporated under the Companies Act number 7 of 2007. You are required to explain whether it is possible under the Act for the secretary to the treasury to be the sole shareholder of the company. Yes, it is. So, what you need to explain here in this answer is that the company law in Sri Lanka allow or permit a single shareholding company to be formed as a public company, whereas the secretary to the treasury is the sole shareholder. And secondly, tasked for Chathura Senarath in his personal capacity to be the sole shareholder of the company? No. That is because, as we saw in the Benjamin's case, that a single shareholder cannot form any of these companies, and the minimum requirement shall be 2 shareholders to form a company. In this question 3, Abu Bakr, a businessman, has been invited to invest in Davidson Private Limited. he has also been given the choice of holding either ordinary shares or preference shares in this company. Outline the features of ordinary shares and preference shares. So what you got to write here is that you give an introduction about what are ordinary shares and ordinary shareholders, and then what are preferential shares or preference shares and preferential shareholders. And thereafter compare or differentiate these two, that what are the benefits that an ordinary shareholder would obtain, or rather preferential shareholder would obtain over an ordinary shareholder. So you are asked to outline the features of ordinary shares and preference shares, and you may also provide a differentiation showing the benefit of a preference shareholder against a ordinary shareholder. This is what you are required to answer. In the second part, it says the articles of Suryakanta Private Limited SPL contain a clause as follows: all preference shares of the company shall be redeemed on the second anniversary of the company, and the consideration shall be paid at the time of such redemption. The consideration shall be computed based on the net asset based value per share. The directors of SPL now wish to know whether the above clause in the article is legally valid and enforceable. You are required to compare the above clause with the relevant provisions of the Companies Act in order to answer the query of the directors. Now we know that under the preferential shares or preference shares, the preference shareholders are required, as per the discussion that we had previously, here, that they have the priority to a fixed dividend and to return of capital in a winding up. So having a clause of such nature as to pay or redeem the redeem at the second anniversary of the company is quite illegal or go against the company law. Now let us go back to our main presentation. Now I would like to take you through the directors and their qualifications. Now I have told you in introduction that directors are the ones that manage the company affairs. They are those who are involved in the administration of the company affairs, and they act as managers as well as agents of the company, having fiduciary duty towards the company. What are the eligibilities of directors? I mean, in the case that who can be a director of a company? Anyone who has attained the age of 18 years. So the age of majority has to be met. In Sri Lanka, under the Age of Majority Act, anyone who has attained the age of 18 is called a major, and anyone who has not attained the age of 18 is called a minor. And therefore, for anyone to become a director, he or she has to attain the age of 18. And also the fact that anyone who is not declared as an insolvent will not be eligible to become a director, which means that will be eligible to become a director, I beg your pardon, which means that an insolvent person cannot become a director of a company. Who is a insolvent? Insolvent means that a person who has been declared as bankrupt, who has been declared as bankrupt. Now, the declaration as a bankrupt person is required. Such a declaration can be only granted by the court in situations where a person is unable to pay off his debt and being declared by the court as an insolvent or a bankrupt person. Such a person is not eligible to become a director, which means in turn that only the solvent persons are eligible to become directors. And thirdly, anyone who was prohibited to act as director under the former law, which is the Act of number 17 of 1982, by which a particular person has been declared as a person not eligible to become a company director, such a person cannot be appointed as a director of a company. And also, anyone who was prohibited to act as director or promoter by virtue of the operations of sections 213, 214 of the former law that dealt with operation and mismanagement of a company, then these people are also not eligible to become a director of a company. And also, under the present law, the same categories of people who have been judged by the court as ineligible to act in such a manner are not able to become directors of the company. Then anyone adjudged a person of unsound mind or having some kind of insanity cannot be appointed a director. Now, here again, likewise in the case of a bankruptcy or insolvency, there needs to be a declaration given by a court that the person is having an insanity. So, it does not mean whether the insanity is curable or uncurable or incurable. Rather, the moment at which a particular person is to be made a director, if that person has a declaration judged by the court as he is not of sound mind, such a person cannot hold the position of a director. And the other situation is where only natural persons can become directors. I told you yesterday that the companies can be formed as alliance, either a mixture of persons and some other companies, or companies and companies, like an alliance. But however, when another company is involved in a particular company's formation, that particular company as a company cannot become a director. That means that then that particular company has to name some natural persons of that particular company to hold directorships in the new company or in the alliance. So, if you take an example of ABC company merging with PQR company, ABC company nor PQR company can become directors, but the natural persons involved in those companies could become directors. It is only the natural persons who can become directors in a company. And then anyone who is not qualified under the articles of the Companies Act, which in this present act says who are not qualified to become a director. Then let me see what is the minimum requirement of a number of directors in a company. Not the minimum number of shareholders, but the minimum number of directors who would manage the affairs of the company. In respect of a public company, there shall be at least minimum of 2 directors. And in other companies, there can be a single director companies, such as a private or guarantee company. There can be a single shareholder company, single director company, I beg your pardon. So, this is different from the shareholding and directorship, whereas we saw that even in that case that I wanted to look in a different way, that a single shareholder can be there only in a public company where Secretary to the Treasury is the single shareholder, but however, no other types of companies that may have single shareholder. But however, in the case of a directorship, a minimum of 2 persons are required for a public company and a minimum of 1, I beg your pardon, director, a minimum of 1 director is required in any other type of a company. So, this is where sometimes students make mistakes, as I show in that previous question, to check that this particular mistake is frequently done. So, I advise you all not to make this mistake in the case of shareholders and directors. Next is, in what circumstance a director could be disqualified. A director could be disqualified. This is a very important area, because there is many concern that directors, while working as directors in companies, due to certain matters, they become disqualified. This is not the fact that at the time they have been ineligible to become directors, but they later on, after becoming directors, they become disqualified to continue with their directorship. The first thing is when a particular director is convicted of an offence punishable by imprisonment under the Companies Act, which means that the particular director has violated certain sections of the Companies Act that imposes penal section or imprisonment for such a violation. So, if a particular director not a person. If such a director is convicted of an offence punishable by imprisonment under the Companies Act, that particular director, he or she, can no longer remain in the director board, can no longer continue to be a director. Secondly, a director convicted of an offence involving dishonest or fraudulent act. Now, it may not be only with regard to the particular company that he is involved with. In any case, if a particular director has committed an offence involving dishonest or fraudulent act, that particular director cannot remain in any of the director boards that he is at that moment being a director. So, he cannot continue. Then also there may be situations where people, after becoming directors, they become insolvent, they become bankrupt and are judged by a competent court, and a declaration being made as to insolvency or bankruptcy. Then such a person, such a director, I would say, can no longer remain as a director of any company. Then, if a particular director has been adjudged to be of unsound mind while continuing his directorship, if a particular director has become or he has fallen into an insanity, then such director can no longer continue with his directorship. Also, where a particular director has been prohibited by court of law to be a director due to some manner. Now, we know, especially nowadays we are talking about cases of criminal acts, especially involving money laundering. So, if a particular director is involved in money laundering and been found to have committed this particular crime, then the court of law will prohibit such director to continue as a director of any company. If a particular director persistently fail to comply with the provisions of the Companies Act and has been noted and referred either by the company registrar or by a particular board in a company or at a general meeting of a company, of the shareholders meeting, or even been adjudged in court, then such a director cannot act or continue as a director if it is proved that he has been persistently failing to comply with the provisions of the Companies Act and convicted of offence involving dishonest or fraudulent act abroad, not only in Sri Lanka, but also if a particular director has been adjudged to have committed a fraudulent act or a dishonest act of dishonest, then such a director can no longer continue as a director of a company. The last situation is where a director being responsible as a director of a company that was declared as insolvent. Now, what is important here is that a particular company has become insolvent or bankrupt, but at the time of bankruptcy or insolvency, this particular director has been responsible as a director in that company that have gone bankrupt. So, where the director been responsible as a director of the company that was declared as insolvent. But suppose that a director had not been found to have been responsible for the bankruptcy or insolvency, then of course, that particular director does not fall within the category of such a disqualification. Let me now discuss about the duties and responsibilities of directors. Duties and responsibilities of directors. What directors are meant to do, what directors ought to do in their affairs of managing the company and acting as directors of the company. What are the duties and responsibilities? Under section 187 of the Companies Act, every director is deemed to act in good faith and for the best interest of the company. So, acting in good faith and for the best interest of the company will be quite subjective than objective. What the director has to do, he has to do for the company's benefit, and also act in good faith, not to act in detriment to the interest and the benefit of the company that he perform his duties as a director. Under section 188, such a director shall not act in a manner contravenes with any provisions of the Companies Act, because we saw that such a director will also be disqualified and discontinued to act as a director if he is found to have acted in contravention with the provisions of the Companies Act. Under section 189, he should maintain the standard of care by not acting recklessly or gross negligently, apply skills and care expected out of a person of his knowledge and experience. What is meant there are quite broad, even though we see that it's just plain as to recklessness or gross negligence and to apply skills and care expected of a person of his knowledge and experience. Now, let me further clarify this maintenance of standard of care by a director, that he should not act recklessly or gross negligently, which means that he should exercise his due diligence and the duty of care towards the company's affairs, shareholders, its customers, company's customers, and all other activities that are involved, that the company is involved in. So, this has a broader meaning. It's not a narrow scope. And he should not commit any breach of such duty of care that would result in loss or damage, not only to the company, but also to those different sectors and people that I mentioned. And also, a person will not be appointed as a director just for the sake of sitting in a boardroom. A person is selected or appointed as a director especially because of the fact that he has the specific skills and competence to act as a director. Now, this is quite dependent on the business of that company or the work of the company. It would differ from one company to another company. Now, if you take an example, a normal manufacturing company requires people who have knowledge about manufacturing and even financial handlings and so forth. Could be also legal. But however, a bank has different types of functions than a manufacturing company. So, the bank directors must have the skills and competence to handle banking matters. Financial company also same. So, therefore, such a director, when comparing to another director, would have different skills pertaining to that particular subject matter for which he is acting as a director in that particular company. So, this is what we say, that apply the skills and care expected out of a person of his knowledge and experience. That also has a broader meaning than the simple terms that are there mentioned in the law. Under section 190, a director should use the information that is available for the company, advise according to the information provided by the employees or professional advisor or expert, any other director or committee of directors. So, the director is under duty, obligation to use this information and advice provided by employees, professional advisors, experts, any other director or committee of directors, individually or collectively. That is to make sure that you take the right decision for the company. So, use your experts available, use the consultants that you have, use the KPIs, the key performance indicators in a company, right? Other available data, resources, information that are necessary for the proper functioning of the company affairs and taking of decisions, and even to cohabit with the employees of the company, top to bottom or bottom to top, in the benefit or an interest of the company to do justice to the company. So, directors are deemed to act in that way. Under section 192, directors have the duty to disclose any personal interest that they may have on company transactions. We see sometimes that there are certain situations, that certain directors act contrary to the interest of the company that they are acting. They get involved in the internal business and thereby causing a breach of the law that states that they are obliged to disclose any personal interest that they have on the company transactions. It does not mean that they should not have any personal dealings with the company, but they should disclose so that the shareholders would get to know, and then the shareholders may decide whether such acts could be tolerated or not. But sometimes certain internal dealings are quite prohibitive. Under section 197, director shall not disclose information to which only the director has access in his capacity or being an employee to any third party or outsider, so as to protect the company's secrets and confidential matters important for the well-being and maintenance of the company affairs. And under section 200, the director is duly obliged to disclose any share dealing having interest in any share of the company, because we know that sometimes, or maybe in most cases, directors do have shares as well. They act in dual capacity as a shareholder and as a director. But however, as long as they are acting as a director, they are bound to follow the director's duties, director's obligations, and they cannot act in contrary to what their shareholding means. Because if you take person A, he may be a shareholder of a company, he may be a director of the same company, but he is acting in two capacities, as a shareholder in once, and on the other hand as a director. So when he is acting as a director, he has to act as a director and be obliged of the director's duties, and disclose also any share dealing he is having interest in any of those shares, because primarily and most imperatively, company is a distinct person, outside and separate from its shareholders and directors. So you are responsible for the company there, and you need to safeguard the interest and benefits of the company. So with that, let me conclude today's lecture, and we will meet you tomorrow. I will meet you tomorrow at the same time at 5:30 in the evening to discuss more on the subject matter of KB3 business law. Thank you very much.